Good morning, everyone. It's very wet and rainy here in London. I hope you're well where you are. This morning's webinar, I'm delighted that we've got a couple of our dispute resolution partners with us. The topic is navigating regulatory disputes, which many of you may have had to deal with the CAA. And with the new DMCC Act coming in, there may be more of the same. So that's the theme today. A couple of housekeeping points. The session is being recorded. You are all off camera and on mute automatically. But if you do have questions, please do put them through the Q&A function on your screen. No question is a silly question, so please do send them through and I will ask them at the right time, or hopefully we'll have time at the end to deal with any at the right time. Without further ado, I will hand over to Rhys, who is going to start the session. He's going to be talking about challenging decisions by the CAA. Kofi will then talk about regulatory investigations, and Veronique will finish up talking about enforcement action under the DMCC, which has just come in. So over to Rhys.
Thanks, Lucy. Morning, everyone. And yeah, as Lucy said, I am talking about challenging decisions by the CAA. And of course, the CAA being probably the most significant regulator for travel companies doing business in the UK, given that they enforce and regulate the compliance with the ATOL regulations and the ATOL regime, as well as actually a bunch of other areas as well, such as the regulations which govern mis-selling holidays, package travel. But my focus today really is going to be on ATOL compliance and ATOL issues. Kofi is going to touch upon the regime and some of the considerations when it comes to compliance with other bits of consumer legislation which affect travel companies. But I'm going to look at the ATOL aspects. So if I can have the next slide, please, Dan. And I think it's worthwhile categorizing sort of areas of disagreement with the CAA into two different categories, because of the legal regime in relation to how you go about resolving disputes with the CAA is different for each category. So I'll go into the various areas in a bit more detail on the following slides. But the two broad areas are what I would call licensing decisions. That's the first category I've got on slide here, which says holding an ATOL and the terms of an ATOL. So this is basically decisions made by licensing officers that you want to challenge or you don't agree with. And the second area is, or the second category is just more general compliance with the ATOL rules. So this is enforcement of the ATOL regulations, which may be done against companies which hold an ATOL or don't hold an ATOL. So there's a different regime there, which I'll go into in more detail on the following slides. Next slide, please, Dan. So just looking first at licensing decisions. And what I mean by licensing decisions are situations where travel company may have applied for an ATOL and it's been refused an ATOL, or it currently has an ATOL, is going through the renewal process and that renewal has been rejected. Quite unusual, but something which could happen. Or it could be a situation where the CAA, before granting an ATOL, want to impose their own license terms on that license, and the most common ones generally being around some security requirements. So they may say, well, we'll grant you an ATOL, but we're only prepared to do it if you give us security. So that could be a bond or a trust account, things like that. Or it could be compliance with a liquidity requirement, whether that's like cash to client monies ratio, a cash floor, those sorts of usual terms that you see in ATOL licenses. Or it could even be around, reporting requirements, which can sometimes be quite onerous. So, decisions around the imposition of license terms is something else which falls within this regime. And the other one is obviously situations where the CAA refused to vary an ATOL. So you have an ATOL, you go to the CAA and you ask them to vary it in some particular way, and they reject it. I should say as well another one which can happen, very infrequent, is if the CAA, having granted an ATOL, decides to revoke your ATOL. So there is a process which applies there as well. So this statutory process is really designed to it's an informal process which I'll go into in a bit more detail on the following slides. But it's a process which basically gives the ATOL holder an opportunity to understand, the CAA's reasons for the decision that they've taken. And obviously it requires the CAA to provide, a written overview of why it is making its decision, as well as providing, substantive documents. So if there's some particular, financial analysis which has taken place, which has led to the conclusion, then to provide that to the ATOL holder, the purpose of which is to give the ATOL holder an opportunity to understand the decision, and an opportunity to kind of make submissions in response, and then an opportunity to actually have an independent third party make a decision about it. So I'm going to explain this in a bit more detail in the following slides. But before doing that, I'm just going to look firstly at the particular grounds of challenge that may exist. So Dan, if you can flip to the next slide, please. So when it comes to licensing decisions, often the way it works is an application goes in and a decision comes back with a load of conditions attached to it from the CAA. And sometimes there can be confusion or a lack of understanding about the grounds upon which ATOL holders or new applicants could challenge those decisions. And there's a bunch of different areas that a challenge could be brought upon, because obviously the CAA don't operate in a vacuum. They have to operate within the confines of the powers given to them under the ATOL regulations. And, those powers include an ability to refuse an application or a renewal application, or to revoke an ATOL in certain circumstances, or to apply conditions to ATOLs in certain circumstances. And one of those circumstances is where the CAA comes to the conclusion that the relevant travel company has failed the financial test. Now, this financial test is set out in the ATOL regulations themselves, as is supplemented by guidance that the CAA has published about how it will implement that financial test in practice. Now, just a quick note on the status of published guidance. I mean, there's obviously guidance published by the CAA doesn't have the same effect as statutes, so it's not the same as the ATOL regulations, but public bodies like the CAA do have a legal obligation to follow their published guidance, their own published guidance, unless there's an exceptional circumstance. And that's just a general sort of public law principle which applies to all different aspects of government and all different regulators. And it's just really a principle of transparency, making sure that people are dealt with consistently and that they know how they're going to be dealt with, and that they can have confidence that they're being dealt with in a way which is consistent with other companies in a similar situation. So the CAA, when it's applying its financial assessment, does have to comply with, certainly has to comply with the test which is in the ATOL regulations, but also follow its own published guidance unless there's some exceptional circumstance. So obviously that means that having received a decision from the CAA, if the CAA have concluded that the relevant company has failed the financial assessment, then there may be grounds to challenge that, depending on the reasons given for for concluding that the travel company has failed the financial assessment. And those reasons may be apparent when you look at the test, which is in the regulations and the guidance, and whether the CAA's conclusions are consistent with that regulatory framework. So that's one area where there may be grounds to challenge a licensing decision. Another one, which is very similar to the financial assessment, is around fitness and competence decisions. So again, the ATOL regulations say that the CAA may refuse to give someone an ATOL, or may decide to revoke someone's ATOL if they fail the what's colloquially referred to as the fit and proper person test. So that's again set out in the ATOL regulations what that test is, and it's also supplemented by guidance which has been published by the CAA. So if the CAA was to conclude that a company was unfit to hold an ATOL, and was to impose conditions on the basis of that conclusion, then that may or may not be challengeable, depending on whether the decision is consistent with the regulatory framework for fitness and competence. Now, a few other things. Another areas. I've already mentioned the importance of following published guidance. I think the other sort of significant guidance note published by the CAA is their guidance note around security. And this applies in circumstances where the CAA, having decided that someone's failed the financial assessment, decide to grant the application in any event, provided that security is given, so that the CAA are in the position, should the travel company fail, to call upon that security to fund the refund and repatriation of consumers. And the CAA has published guidance notes to say the circumstances in which it may ask for security, the type of security it may ask for, how that security will be calculated, and also exceptions to the general rule. So again, if there is a licensing decision which is inconsistent with that published policy, then again, that's something that could give grounds to challenge the decision of the CAA. Other perhaps more nebulous, less clear areas to challenge the CAA are just on what I call general public law principles. So, and these rules apply to all regulators and governmental departments. The first of which is proportionality. So, this is a situation. So, public bodies have obligations to act proportionately in relation to those that they regulate. And one of the areas where this could come into play in the ATOL sense is where to put it colloquially, a sledgehammer is used to crack a nut. And to give you a very crude example of this, let's say that the maximum amount of customer monies that a travel company holds at any one point is £1 million, and the CAA was to ask for security, a bond or a trust account of £2 million, then obviously you can see there where there may be arguments around proportionality, because what you would be saying is, there is no need for a buffer of £1 million. It serves no purpose. There's a cost to us and a disadvantage to us in having to provide that, and no real need for it, because it's in excess of what may be needed to meet the costs of refunding and repatriating consumers. So that's kind of a crude example of a proportionality argument, but that's the kind of thing that you're looking at there. Other areas as well around sort of irrationality. This could be a situation where the CAA has made a decision which is just kind of not logical. It's not rational. Maybe they've taken into account something which just isn't relevant to the ATOL holder. Maybe there's no sense to a particular decision. So it could be something like a risk having been identified in a different part of the group, which actually has no potential bearing on the ATOL holder itself. So you could say that's an irrelevant factor which shouldn't have been taken into account when it comes to looking at the licensing of the ATOL holder. So these rationality arguments are all to do with whether the CAA has considered the relevant circumstances, hasn't taken into account the irrelevant circumstances, and has made a rational decision. And then the last one I just want to mention in terms of grounds of challenge is just around sort of procedural unfairness. And this is really situations where you might not have been given proper reasons for a decision. You might not have been given proper time to consider a decision. So just really fairness arguments which go to the process and the procedure, as opposed to the substantive decision that the CAA may have made. So these are sort of potential grounds of challenge with licensing decisions. If we come on to the process on the next slide, please, Dan. There is actually a process for resolving these areas of disagreement around licensing decisions, which is set out in the ATOL regulations. And like I said, the process is designed to achieve those objectives I talked about earlier in terms of giving the ATOL holder full transparency on the decision, allowing the ATOL holder to understand the analysis for decisions, to see the documents being relied upon or the evidence which is being relied upon in support of those decisions, and then being given an opportunity to make submissions in response, and then have that decision ultimately made, and then have the matter ultimately decided by someone who is separate and quasi-independent, I should say, from the licensing officer itself. So the way it works is if you have applied through a New Year ATOL and the CAA want to impose conditions on you, or don't want to grant you a renewal, and if you're not prepared to accept the CAA's conclusions by consent, then what the licensing officer has to do is to prepare a written document, which is a proposal, effectively, setting out the reasons for the decision, setting out the evidence in support of the decision, and attaching relevant documents. And that proposal goes to a CAA board member who will ultimately make the decision. That proposal will also be sent to the travel company, and then within a 21-day process, at the minimum, can be longer, but within that time frame, the ATOL holder or the applicant is given an opportunity to prepare a written submission in response to what the licensing officer has prepared, and again attaching any relevant documents or analysis, anything that the travel company wants the board member to take into account. And that then goes to the board member. And the CAA board member can then decide the matter just on paper, just having read what everyone has submitted. Or alternatively, it is possible, particularly if the ATOL holder of the travel company wants to appear before the board member to make their arguments in person, then they can ask for a hearing and then go along and make oral submissions, and they can also bring along anybody that they want to act as a witness and give some further information to the board member, and then there'd be sort of an opportunity to ask questions before the board member ultimately makes the decision. So that is the process leading up to the decision. And I should say that the hearing in front of the board member is held in public as a general rule, unless there's some exceptional reason why it shouldn't be held in public. And then after that hearing takes place, the board member has to make a decision and provide reasons for the decision so that the ATOL holder can again understand the reasons for the decision, why it's been made, which then gives the ATOL holder the opportunity, if they want to challenge that further. And the way that they would do that is start a claim in the High Court or in the County Court around fitness decisions. So there is an appeal, a right to challenge these decisions in the court after the board members made their decision. So next slide, please, Dan. So that's the statutory process. I suspect that for most people listening to this webinar, this will be kind of a bit of a surprise, quite foreign, not something that they've really heard about before. And that's because, in practice, this process is very, very rarely, if ever, implemented. And I suspect because, part of the reason for this is that it's actually quite a burdensome process for the CAA to go through, particularly if you consider, the number of license holders that they've got. Clearly be impractical to go through this process for a large number of ATOL holders, at the same time during, March or September renewals. So what tends to happen in practice, as I'm sure everyone who holds an ATOL is familiar with, is having applied for an ATOL or having applied to renew your ATOL, you tend to get kind of indicative terms from the CAA, and what that really is basically saying, well, look, we would be prepared to grant your application provided you agreed to do the following, and if you agree to that, if you then reapply on those terms, the CAA will just agree to it by consent. And if that happens, if a decision is made by consent in that way, there is no need to go through this statutory process, and that's what happens in practice. And often, having had those indicative terms, there's a bit of back and forth, perhaps there's a bit of negotiation, often up against the deadline of the expiry of the existing ATOL. So travel companies are usually under quite a bit of pressure just to agree something with the CAA so that they can get their ATOL renewed, and that's usually enough pressure to lead to a resolution, even if that's imperfect for the travel company. I should say that sort of timing issue of license expiry is one that can be resolved if you genuinely do want to go down the statutory process and have your case heard in front of the CAA board member, or maybe have more time to negotiate with the CAA, or provide your reasons to the CAA as to why they've got the decision wrong. And the way to deal with the timing issue with license expiry is just to apply in relation to your existing ATOL to have that extended by enough time to enable the statutory process to be gone through. So that could be a short extension of 30 days, 60 days, however long is needed to go through the process. So that's all I wanted to say on licensing decisions. If you can just flip to the next slide, please, Dan. And this is my final slides, where I'm just going to talk briefly about other areas where there may be disagreements with the CAA. And this is in relation to compliance with the ATOL regulations more generally. Because as I said at the outset, the CAA are the regulator responsible for enforcing the ATOL regulations, and they can do that against companies which hold an ATOL or companies which don't hold an ATOL, because compliance with the ATOL regulations can mean taking enforcement action against companies which are selling regulated products which are not currently being ATOL protected. So there could be somebody who is selling a flight inclusive package to consumers in the UK without having ATOL protected it. So that's an example of what I mean by enforcement of the ATOL regulations. And this is the same category which involves not complying with the rules around ATOL certificates, not complying with the rules around the sales and marketing rules around ATOL, which are set out in the ATOL standard terms, not complying with your license terms around security requirements, or not notifying the CAA of things that you're obliged to notify them about under the terms of your ATOL, such as a change of control or other material events concerning the company. There's really two ways currently for the CAA to enforce, or two legal procedures that the CAA can rely upon. I mean, the first one is to make licensing decisions, like I've already spoken about. So, the CAA may take into account, as part of, the fitness and competence test, the fact that an ATOL holder hasn't been complying with the ATOL rules. So, it is possible for these breaches to lead to kind of ATOL revocation issues, or rejection of ATOL applications. That's of course is only relevant to travel companies which hold an ATOL. The other enforcement tool that they have is, for a breach of the ATOL rules, is to bring a criminal prosecution, which is obviously a nuclear option and very rarely used in practice. But at the moment is the only tool that the CAA have if they want to bring kind of formal enforcement action for non-compliance with the ATOL regulations, and that would be starting a criminal prosecution in the criminal courts against the relevant company or against individuals within the company for not complying with the ATOL rules. In practice, as I said, that is a nuclear option. It's not really something that you see the CAA use when it comes to perhaps disagreements about the interpretation of how a particular rule should be complied with. So what you tend to have in practice is a process where the CAA will engage with a travel company around something that they're doing, and then there will be an opportunity to discuss, engage, try to come to a compromise on a particular issue, whether it's the way that ATOL certificates are being issued or the timing of issue, or things like that. There is usually a process of engagement because, as I mentioned, the CAA don't really want to have to use these criminal enforcement powers, given how draconian, high profile, time consuming and expensive that they are. So through this process of engagement, there is usually enough motivation on both sides to reach a compromise. So that's where we are with these at the moment. I should just flag that it's not happening at the moment, but the CAA have been asking the governments to give them more powers to be able to enforce compliance with the ATOL rules. And the thing that I think they're particularly keen to have are civil enforcement powers, or perhaps direct enforcement powers, like the CMA have just been given. And both of those tools, Kofi and Veronique will talk about in a bit more detail. But that's what they're asking for from the government in that respect. So that's all I have to say on my bit. I don't know if there are any other questions to take at this stage, because I should have said at the outset that I am going to disappear and let Lucy, Kofi and Veronique take on the webinar from here. So if anyone has any questions, please feel free to drop them in the Q&A box. Otherwise, we will pass on, I think, to Kofi next.
Okay. Good morning, everyone. My name is Kofi. I'm a partner in the disputes team, and I'm going to talk about some practical do's and don'ts for regulatory investigations that travel companies may face. Can I get the next slide, please, Dan? Before getting into the nuts and bolts of the practical tips, I wanted just to step back slightly and give a slight overview of the sources of investigations that travel companies might face, the nature of those potential investigations, and some of the powers that regulators have to compel the cooperation of travel companies. So starting here with this slide on the sources of regulatory investigations, we've got three buckets that we've separated them into. Obviously, the first one being the CAA, because they are the main regulator in this space. And you can see here that, as Rhys touched upon, the CAA can deal with or investigate breaches of your ATOL or of the ATOL rules, the standard terms, breaches of the PTRs, and also mis-selling of holidays, which has a statutory basis in the new legislation that my colleague Veronique will speak about shortly. So the CAA is the key regulator, of course, but it's also important to remember, moving to the second bucket, that you have the CMA and trading standards, who can investigate the same sorts of things, breaches of the PTRs, mis-selling of holidays. And also in the third bucket there, you see other potential regulators. Important to bear in mind the FCA, who will have oversight and ability to investigate to the extent that travel companies are assisting customers to finance their holidays or providing insurance services. The FCA can, in those circumstances, investigate breaches of the relevant regulations in that space. And of course, depending on how your business is organized, you could also be subject to foreign regulatory investigation. Okay, so that's the sources. Can we have the next slide, please, Dan? Thanks. And again, just in terms of overview before we get into the specific points, because these will all inform those practical points, you see here that there are different bases on which regulators can investigate the activities of travel companies. It can be criminal, it can be civil, and of course there is on the civil side I think Rhys described criminal enforcement as the nuclear option, but obviously ATOL revocation is also a very serious potential outcome. So when you're facing an investigation or you're thinking about how you would deal with regulatory investigations, please bear in mind not only that there are varying sources of potential investigation, but also that there are varying types, and some of them potentially can be very serious, particularly on the criminal side. Next slide, please. Okay. So finally, before we get into the tips themselves, I think it's important just to take a quick look at some of the powers that regulators have to investigate travel companies and to compel compliance. This list is not a complete list, but it has some of sort of the key powers that you should keep in mind. If we start with the ATOL powers, there are specific powers under the standard terms which enable the CAA, as it says in the first sub-bullet point there, to require you as an ATOL holder to provide all documents and information relating to your financial affairs and resources. I think it's important to also bear in mind that that obligation can be applied not only to the specific company holding the license, but also to its group companies and to related parties. Similarly, you may be required to produce financial records and systems, not only at your individual level, being the company holding the license, but also at group level. And this is important for the slides we'll come on to in terms of the do's and don'ts and ensuring that you have proper systems and controls in place to be able to produce these documents if and when you need to. Moving on to the CRA powers there, you'll see that these statutory powers can be used by several regulators, the CAA, of course, but also the CMA and trading standards. And again, this act gives powers specifically to investigate breaches of PTRs, the mis-selling of holidays, as we discussed before. Again, you'll see in the fourth bullet under that CRA powers section, there is a power to compel the production of information and documents So this is an important sort of across the board power that almost all regulators will have, is they can force you to give up documents and information subject to legal privilege, which we'll come to in a moment. And the next bullet point is also important just to dwell on briefly, because there will soon be turnover-based fines for not providing information to regulators. Aside from any punishment, I should also say as a general point that if you, as a travel company, are seen as being non-cooperative, either intentionally or because you don't have the proper systems in place to respond to requests, that obviously creates a bad impression with the regulator, which can make it more difficult then to influence the course of the investigation in the way that we would like to. Finally, before we get into the practical points themselves, you see that there's a power to enter premises in certain circumstances. So all of that is really to say that investigations by regulators can come from many sources, can have varying forms, and can have real teeth in terms of your obligations as a travel company to comply with the requests that are being made. Okay, so let's move on to the practical tips themselves. Thanks, Dan. You will see that all of these tips across this slide and the following slide really have three key themes. They are about essentially preserving documents, ensuring that there's clear management and clear communication within the investigation, and protecting legal professional privilege. So that is, as it were, the holy trinity that you should be keeping in your mind whenever there is a regulatory investigation into you or into a related company. Okay, so let's go through some of the points, which I hope will be fairly intuitive. They're supposed to be common sense, practical points for you to keep in mind. So first, do immediately suspend all routine document destruction. Consider which document sources may need to be segregated. Notify the relevant employees, obviously, of the need to identify and preserve documents, and don't allow any potentially relevant documents to be destroyed or archived or deleted. I should say that when we refer to relevant employees, what that means is all staff who are involved in the matters being investigated, or who may possess or create documents that are relevant to the investigation. So just give a little bit of thought at the outset as to who that may be, because it may draw in a wider pool of people than is immediately obvious when you first learn about the investigation. Moving to that fourth bullet point there, do control internal communications within the company while the investigation is ongoing, and consider whether you want the senior management updates to be provided by either in-house counsel or external counsel, and whether the external legal advice should be conveyed on a confidential basis. I can tell you that it should be conveyed on a confidential basis. And those 2 points are really about, again, ensuring that you have clear lines of communication and everybody understands who is supposed to be communicating material facts or material updates about what is happening, so that there's complete clarity, because that will help you to present your position to the regulator in the best possible way. But also in order to protect legal professional privilege, which I'm sure you're all familiar with, but broadly speaking is about being able to withhold and not hand over documents and advice, or documents and information which relate to legal advice that you're receiving. So that is a legal right that you have, and it's important to protect that right. And a key quality of privilege is confidentiality. So if the documents are not confidential, if the communications are not confidential, they cannot be privileged. So that's an important point. Moving to the next bullet there, you see, do instruct external counsel as early as possible in the process, said the external counsel. I don't include that point from a purely self-interested perspective. It is actually important, I think, even if it's a highly sensitive investigation, uh, even if it's an investigation which you, in the first instance, would like to control within the company itself. I think it is important to consult external counsel and possibly instruct external counsel at the outset, because you want to avoid any strategic errors, for example, around allowing the scope to be defined too broadly, or accidentally or inadvertently waiving privilege. Similarly, for that last bullet point, it may in certain circumstances be necessary to instruct external experts to assist you in the investigation, or to assist you in responding to requests from a regulator. And if you find yourself in that position, for example, that you need forensic accountants to assist or accountants to assist because you're being asked to provide financial data, consider having those experts instructed not by you directly, but via your lawyers. The reason to do that is because if those experts are being instructed by the lawyers, so that the lawyers can consider what they provide in order to give you legal advice, that will cloak the work product of those experts with legal professional privilege as well. So, in other words, if you instruct them through the lawyers, you have more control over what they produce and whether what they produce has to be shared with the regulator. So that is an important point to bear in mind, and another reason why, as soon as you learn that an investigation is happening or is imminent, one of the things you want to think about is, do we need external counsel? Or do we need at least to speak with external counsel to kind of scope how we're going to run the investigation? Okay, can we have the next slide, please, Dan? Thank you. Again, all of these points go to the same priorities: preserving the documents, having clarity of management and communication, and preserving your privilege. So let's go through them. Do identify specific individuals to manage the investigation. This is really important, not only for clarity, but also because the fewer people and the more clearly defined the group of people within the company who are managing the investigation and who are dealing with the regulator, the easier it is to assert privilege. What I mean by that is, for example, if your company has 100 people in it, and all 100 of those people can instruct the lawyers, can manage the investigation, can liaise with the regulator, it becomes far more difficult to maintain that sort of confidentiality, and far more difficult to be clear about who is in charge of what. So an early task, I think, is to identify a group of people who are going to take ownership of the investigation within the company. And that's whether or not you are instructing external counsel to assist you. I hope that the next bullet is obvious, but I thought it was worth us flagging anyway, which is that the senior in-house lawyer should be part of the internal investigation team if you have one. I'll say no more about that. You can also ensure that the in-house lawyer is the only person who communicates about the investigation to others within the business. Again, that's about preserving privilege and about having clarity in who is responsible. The next bullet point is really covering similar ground. Not only should the in-house lawyer take ownership of the internal communications about the investigation, that person or that group should be the only ones who really deal with the regulator if external counsel are not being used. If you have external counsel, then obviously they should be the direct point of contact. But in either case, you want everybody within the company to understand that there is a select group who are dealing with this, and that if in doubt, the senior in-house lawyer is the person to relay questions to seek information from, and the person who's going to lead the communications either with external counsel and or with the regulator. Okay, so the next point is do ensure that the internal investigation team excludes anyone who is being investigated or whose conduct is being investigated or who's connected to those being investigated. Now, that may sound obvious. I hope it does. But it's important to add that sometimes people can have a connection to the investigation, even if their own conduct is not specifically being looked at. So, for example, you may have overall managerial responsibility or financial responsibility for people whose conduct is potentially being questioned. For example, if there's, I don't know, a mis-selling allegation or something like that. Those who have that management responsibility or those whose financial performance is measured by reference to the activities of those being investigated should not be part of that internal investigation team as a matter of best practice. Because you want, obviously, the investigation to be completely unimpeachable. And the guiding principle I think it's helpful to have is if everything that we are doing was fully exposed to the regulator, how comfortable would we be in justifying it? So if in doubt, let that be your guiding principle. Last 2 bullet points here. Consult external counsel before making any substantive comments or commitments. This is important. Again, given what we've said earlier about the importance of complying with regulators, it can be tempting simply to respond as quickly as possible and just say everything that you can think of that is responsive. I would urge you just to consult with, in the first instance, the in-house lawyer, but also external counsel, because sometimes a request may not need to be responded to in the way that the regulator is asking, because perhaps they've misunderstood the nature of the business or the nature of the information that you have, or what is really relevant. So it's worth just being coordinated in the way that you respond to requests. And finally, don't share information or documents from external legal counsel with anyone outside of that internal investigation team. That is important because the documents and information you receive from your external lawyers is in the first instance privileged. It was created to advise you in the context of the investigation. And if it's too widely disseminated, there is a risk that it loses that quality of confidentiality between lawyer and client. I hope, as I say, that all of those points were fairly intuitive, but it can be easy to forget them in the heat of a sudden and serious investigation. Okay, I'm now going to hand over to my colleague Veronique, who will speak about enforcement action under the new legislation. Veronique.
Okay, thanks, Kofi. Good morning, everyone. So I will spend the next 10 minutes or so looking ahead. So what's to come? The Digital Markets Competition and Consumer Act. I'm sure most of you have heard a lot about this before and will be fairly familiar, certainly with aspects of it. So it's being implemented in a phased process. The aspects I'm talking about today are expected to come into force in the spring. So as many of you will be aware, landmark piece of legislation that's going to equip the Competition and Markets Authority with powers to enforce breaches of consumer protection laws directly. And this is going to include imposing fines on businesses who don't comply with the relevant legislation. So I will cover very briefly, I'll give you a quick overview of what the DMCC covers. I'll explain the powers that are being given to the CMA, the process that's going to be followed in the event of an investigation and enforcement action by them. And then in the event of enforcement action, the sanctions that non-compliant businesses and potentially individuals could find themselves subjected to. So if we could move on to the next slide, please, Dan. Thank you. So the relevant consumer legislation that is covered by the CMCC is listed within the Act. We've set out on the slide here those that are most relevant for travel businesses. So as many of you are very familiar with the Consumer Rights Act, obviously that's concerned with carrying out services with reasonable skill and care, and the requirement to impose fair terms and conditions on customers. And then you've got the consumer protection from unfair trading regs. So that's effectively being copied and pasted into the DMCC. And that is concerned with ensuring that dealing with marketing practices, sales techniques, and treating customers fairly. So that is going to include typical kind of things that we see within the travel industry is things like creating a false sense of urgency to pressurize customers into entering into transactions. So that's, for example, using tools such as countdown timers that we see, indicating that an offer's only available for a limited period of time, or that a transaction needs to be completed within a short period of time, when that's in fact not true. Other things we see is things like false claims that other customers are looking at the same deal and that that offer's soon going to run out. False discount claims is another one. So advertising a special offer when actually that holiday has never in fact been offered for that higher price. And then price dripping, so providing a headline price that's given, but by the time the customer comes to actually book the holiday, all sorts of unavoidable fees have been added. So you're drawing the customer in with a really attractive low price, but inevitably when they come to book, that price is much higher once you've added things like taxes or unavoidable booking fees. And then consumer contract regulations are also covered. So these require travel businesses to provide certain information to customers before they book, and a right to cancel, although that's generally not applicable to package holidays. And then, of course, the package travel regs, that's also covered, which, of course, governs the sale of package holidays and travel arrangements in the UK. Next slide, please, Dan. So what about the new direct enforcement powers? What's it all about? Well, as it stands, the current position is that the CMA has to go to court to get an order against any business that's acting in breach of consumer law. That's akin to getting an injunction, so requiring the travel business to take certain action. So, for example, it might be an order requiring them to remove misleading information from their website. But even if they're successful in getting that order, there's currently no power to impose any fines on the business for that breach of consumer legislation. So that's all going to change. The former chair of the CMA has described the CMA's current powers as unfit for its current purpose and far short of what would be required to enable the CMA effectively to fulfill a consumer interest duty. So the DMCC is all about fixing this issue, and it's doing that by giving the CMA power to take direct enforcement action without having to go to the court. So under the DMCC, the CMA is going to decide for itself whether there's been a breach. It's then going to decide whether to impose a sanction, and if so, what that will be. And so significantly, businesses who are determined by the CMA to have failed to comply with the relevant consumer law can now be fined up to 10% of their group level turnover, or £300,000, whichever is higher. So that could also include a requirement for businesses to compensate customers. It's obviously a huge number, or potential number, and it's plainly intended to be a deterrent and cause some real kind of improvement in the way that businesses operate in the consumer area. So the power's been taken from the hands of the court, placed in the hands of the CMA. We're going to see that enforcement regime really speed up. Obviously, court processes take a long time, they're costly, but this new enforcement process will be a lot quicker, and from the CMA's perspective, a lot more effective. How is this going to work in practice? the process. So it's going to start with the CMA commencing an investigation, usually with an information request to the travel company, if that's the case, requesting information that the CMA is going to need to enable them to determine whether there has been a breach of consumer law. So at this point, the business is going to have to think really carefully about the information that they're going to provide. And it's going to be absolutely fundamental that they ensure that the information is being provided is accurate and not misleading. But it's this balancing act because requests can often be very broad. So it's going to be really necessary to consider corresponding with the CMA with advice to determine an appropriate scope, and then also to agree realistic timings. At the absolute outset, it's also really important to consider whether it's appropriate to offer undertakings, and I'll deal with undertakings again in a moment. Also worth bearing in mind, the CMA often do publicise the fact of an investigation on their website, and that can often then be picked up by the media, so all the more reason to try and nip these things in the bud at the earliest possible opportunity. So then the next stage will be for the CMA to review the information that they've received from the business, and they'll issue what will be known as a provisional enforcement notice. That will set out the investigation, the findings, whether the CMA have determined that there's been a breach, what that offending conduct has been, and then set out a remediation action plan. If the CMA are considering making a fine, the provisional enforcement notice will also have details of that in there. So again, at this point, the business is going to want to very carefully consider and assess whether the CMA has made any errors or misunderstood any facts or issues. Perhaps something needs clarifying. And it's going to be another important opportunity to consider whether it's appropriate to offer some undertakings to bring the matter to a close. There are instances, of course, where the CMA might need to be educated. So during COVID, we saw travel businesses being required by the CMA to refund customers for cancelled holidays. But that was in circumstances where the airlines were separately refunding customers for the cancelled flight. So this would have resulted in customers being overcompensated. And the CMA hadn't appreciated that. So it is really important to obviously consider, well, is there some information that needs to be shared with the CMA that will have a major impact on any enforcement notice. And then at that point, the business will have an opportunity to make those submissions in a response. So the CMA will then consider the submissions and then issue a final notice, a final enforcement notice, which the CMA often requires travel businesses to publish on their website. And at this point, it will be up to the business to either accept, appeal, or appeal aspects of the decision to the High Court. Next slide, please. Thank you. So undertakings, I briefly mentioned undertakings. So once the CMA started an investigation, the business is going to want to obviously bring the matter to a close as soon as possible in the interest of certainty and to avoid further unwanted negative publicity. The business is going to be dealing with the CMA as a judge and the investigator. So if it's appropriate to do so, the option of offering undertakings as early as possible can be a really good, course of action. There will be instances where the business will not, it'll be important to challenge the CMA's conclusions or criticisms. But where there's been an obvious breach, the business should be really active in offering undertakings sooner rather than later, because it gives the business an opportunity to shape them before the CMA produces its own first draft. So getting in there first just to kind of retain a little bit of control or try and shape what that conclusion might look like. If the CMA accepts the undertakings, that's fantastic news. That'll be the end of the matter as long as the undertakings are then complied with. If they're not, then the CMA has the power to enforce them by serving an undertakings enforcement notice, and under its new powers impose additional fines, and that will be in addition to the fines that have been imposed for the initial breach. Next slide, please. I will canter through these next slides because I'm conscious of time, but we've just set out on the slide there the potential additional fines. So as I mentioned, this is an additional, there's been a breach of consumer law, there's been a fine issued in respect of those breaches, but if there are additional kind of misconducts. If, for example, not complying with a final infringement notice, not complying with undertakings, additional potentially, 5% of group turnover or daily group turnover, if we're talking about continuing breaches, that they're going to be additional powerful fines that the CMA can impose to ensure that the businesses act compliantly. Next slide, please. So I've obviously talked about the importance of giving accurate information during the investigation process. So yeah, a further 1% of group turnover could be fined for giving false information to the CMA during the investigation. And then similarly on the next slide, please, a further 1% of group turnover or 30,000, whichever is the higher, for failing to give the CMA the information they've asked for. Which again, the reason I mentioned was, trying to agree realistic timeframes for providing information. You want to ensure that you're acting cooperatively and don't find yourself on the receiving end of an additional fine under these new powers. Next slide, please. So yeah, just to close off, other important matters to consider. This is a really interesting one, liability for individuals. So the DMCC includes liability for individuals as well as the business. We're talking about directors, managers, secretaries, or other persons who control the business if they have consented or connived in the breach of consumer law. There's been not a huge amount of discussion about when this might, at what point the CMA might, or in which circumstances the CMA might deploy this power. So it's something we're looking into and giving some further thought and research to. And then just finally, worth bearing in mind that under the DMCC, regulators such as the CAA and trading standards, they haven't been given the power to impose the same fines directly, but when they go off to court following an investigation, they will be able to ask the court to impose the same level of fines. So that's a really interesting, wide-ranging power that's been afforded to kind of regulators across the board. So look, I'm conscious we're 3 minutes over, so that brings my section to a close. Thank you very much, and I'll hand back over to Lucy to close us out.
Great, thanks, Veronique. Yeah, sadly, time has beaten us. We have had some questions in, some of which we've answered during the session. There's a couple more which we will respond to separately. So if you leave your email addresses, we'll make sure we'll get back to you on those. And anything else, obviously our contact details are on the slide. Thank you very much for joining us today. Thanks, Kofi, Veronique and Rhys, and we will see you all very soon. Have a great day.